Right, back live tonight on In Focus, and thanks for staying on. The Information Regulator has found that police violated the POPIA Act by disclosing personal information of the Krugersdorp gang rape victims. The Protection of Personal Information Act is South Africa's data protection law designed to protect people's privacy, which is considered a human right. The Act outlines when it is legal for one entity to process personal information. The regulator has ordered the South African Police Service to publicly apologize for failing to take the appropriate measures to prevent the unlawful accessing of personal information. To take us through this further, we're now joined by Mfana Gwala, board member at the Information Regulator. Gwala, good evening, and thank you very much for coming on tonight. The fact that we are saying you have found, it means that you conducted some kind of investigation. It's a broad investigation. First and foremost, the Krugersdorp rape matter is one of the many investigations that you were conducting. What prompted the investigations?
Firstly, thank you very much for inviting us this evening, Mr. Mdluli. You know, the Information Regulator is responsible for two pieces of legislation, which is the POPIA, which is Protection of Personal Information Act, and PIA. So wherever our jurisdiction extends to areas where there has been a violation of or unlawful processing of personal information, and by law we are expected to intervene. And in this case, it was a clear case where, what the gruesome act that was visited upon those women on that fateful day, in itself was very painful and atrocious. But I think what also then happened subsequent to that, the people who are supposed to be providing protection and investigating and bringing those people who committed that gruesome act against these women should have been brought to book. We're now responsible for unlawfully processing the information of those women who were violated on that day by distributing a message through WhatsApp, Facebook, and a number of other social media. You know, information that was revealing a lot of personal information of the victims, to an extent that I think one would simply say that, they were being handed over to the slaughterhouse, because, if you've been violated and these people are being investigated, now we are educating them about the information, the details, the addresses of the people that have been violated, so that it gives you an opportunity to can even intimidate them from opening cases against you or even thinking about testifying. So that's why the Information Regulator then intervened. We conducted an investigation in terms of POPIA because we are enjoined by the Act where there has been interference with personal information of a person, or in this case, in the context of the Act, we call them data subjects. We are then enjoined by the Act to investigate. So we conducted a very extensive investigation, and we came to the conclusion that the conduct of the South African police by distributing the personal information of the people who were violated on that day through WhatsApp message, that processing of that information was unlawful, was unreasonable, and the manner in which it was done, it infringed on the privacy of the people who were violated on that day. Secondly, we found that the personal information of the data subject contained in the WhatsApp message was excessive. It included addresses, ID numbers, and I don't want to repeat some of them from how many times they were violated on that particular day. If you remember, they were robbed and raped, and that information was contained there, where they are staying and so on. And we feel that that was, it is our considered view that that was excessive and unnecessary, even though the police were trying to justify it by saying, they were sending the information to their various police stations in the area, to try and mobilize resources to respond to that crime that had been committed at that time. Quite clearly, I think the manner in which that was done, obviously it led to unintended consequences. And finally, we're saying the police failed to take appropriate and reasonable technical measures to prevent the unlawful accessing of personal information of those people who were violated on that day in terms of as prescribed by the Protection of Personal Information Act. Yes.
Now, Papa, was what do you call it, the offense, the fact that this was leaked on social media, or was it an offense for the police themselves? Was it improper for the police themselves to be sharing the information amongst themselves?
Mr. Mdluli, if you are in possession of my information, for whatever reason, now in this case, let's use an example of Newzroom. You collect data, and that data is in your possession. Once you do that, once you start processing personal information, and in most cases it would be with consent of the data subject, or sometimes you will be enjoined by some pieces of legislation to do so. Like the police in this case, they collect this kind of information because a crime has been committed. They need to know who the victims are and the nature of the crime that was committed. So that information is in the possession of the police at that particular time. The law, or POPIA in this respect, enjoins the police to ensure the safeguard, protect the safeguard and the integrity of that information. So leaking is tantamount to a breach of that responsibility by police, because once they have your own personal information, you don't expect your personal information to be published or be leaked into the media. I mean, this information was shared with almost everybody, amongst others, police officials, the cleaners, and eventually it ended up on Facebook pages of people and in group chats and so on. And all these people who access that information, in fact, we suspect even the people who committed this crime, there's a possibility that they got hold of this kind of information. So the police, by allowing that information to leak, they violated the provisions of the Protection of Personal Information Act. So that was the offense. That was the nature of the act.
Right. Is it within the nature of the work that you do as the regulator to then investigate the leak itself, or you are confined to the fact that, well, it was leaked, and the fact that it was leaked, then it is a violation?
Like I said, the Information Regulator is responsible for the protection of two rights that are enshrined in the Constitution. That's the right to privacy and the promotion of access to information. So those two pieces of legislation, POPIA and PIA, in this case is Promotion of Access to Information Act, fall within our jurisdiction. That is the purpose why we were created, to make sure that people comply with the provisions of those two pieces of legislation. In short, to ensure that we protect your privacy, we ensure that your privacy is not violated, unless when there's a justification in law to do so. Yeah. In this case, what we are saying is that, you can't, as police, share, allow information like that to leak, because firstly, it compromises your work, the investigation, because already you would have educated the criminals that have committed this act, and they will start covering their tracks. They may even victimize the victims again. It's basically tantamount to double jeopardy against those people who were violated on that day. So whenever there has been an interference or unlawful processing of personal information, it falls within our jurisdiction, and we have powers to investigate and take the necessary measures against the person responsible for that.
So the duty then to now deal with those who would have had the responsibility of the information and it leaked in their hands, is that duty that lies with you, or now it lies with the policing processes and the systems there of how they bring discipline?
Okay, just repeat. I think I missed the last part.
I'm saying the duty is the duty now to discipline those on whom the information was leaked yours, or is that the discipline that now lies with the South African Police Service itself? Yours is to find that, of course, they failed to to keep to their duty to protect the information. You've asked them to publicly apologize. You've asked them to enter into a process of teaching the police around the POPIA Act and how they should behave. But is that where it ends, or is there more in as far as sanctions that should be meted out on those in whom the information was leaked?
Yeah, the decisions that we take insofar as that is concerned, they are, let me say, similar to the public protector. They are binding, and we expect people to follow them. Failure to follow them, sometimes the Act says you're committing an offense, which may result in either imprisonment, and in this case it could be the commission of police, because the violation was committed by the police themselves, imprisonment, fine, or both. And you can also be fined up to about 10 million rand. So we have powers, certain powers to enforce non-compliance. And in this case, obviously, it becomes much easier for the police to then take disciplinary steps against those people, because quite clearly the police, at the end of the day, they accept the fact that what was done on that day, it's not consistent with the standard operation police procedures of the police. It had nothing to do with the mobilization of resources by the police to respond to the crime that was committed. Instead, it led to unintended consequences in this respect, where the dignity and the dignity of those women was further violated by the information being circulated in social media. So we can actually direct the responsible party to take certain steps to correct the situation or to address the non-compliance.
Right. So what was the expectation as far as the regulator is concerned? Maybe it's just to educate people around the work that you do. What was the expectation? The police had this information in their possession. They had the duty to protect it. When they found out that the information, of course, was out in the media, it was on social media and so on and so forth, what actions were they actually supposed to take?
Yeah, so I think that's a very good question, because it amounts to, in certain instances, I'm sure you've heard, Mr. Mjuli, circumstances where in various companies or corporates, there's been a breach of information. For example, issues like spyware, somebody is able to hack your system and access the data. So the Act says in that situation, you are supposed to first and foremost report to the Information Regulator. Section 22 of the Protection of Personal Information makes it a duty in a situation where there's been a leak or a compromise or a breach on the data of people that is in your possession, to then report. And this is a formal process where you report in a particular way, amongst other things, to what extent has been the breach, what measures have you taken to mitigate the breach, and also you've got an obligation to inform those people whose information has been compromised so that they become aware, and also obviously they'll be entitled to exercise their option in that respect. So it makes it's actually a duty. Your possession of personal information, it gives you an obligation to ensure that you ensure the safeguard or the protection of that information, that it does not leak. And where it leaks, you must demonstrate that you've taken certain measures. And in this case, the police at first were very defensive. The information, we contacted the police. We were expecting the police to contact us, because when there's been a breach, you have an obligation to then inform the regulator by your own initiative and say that we were in possession of this information. There's been a breach. This is the nature of the breach. These are the measures that we've taken. These are the people, the number of people affected by that breach, and the steps that you've taken to inform those people to make sure that they try and mitigate the breach. And in this case, nothing of the sort happened until we informed the South African police that we are investigating the matter. We subpoenaed we actually summoned them to come and appear before us and explain themselves. We also asked for further information and conduct further investigation. And at the end of the day, that issue is then referred to what is called the Enforcement Committee of the regulator. The Enforcement Committee then looks at the information presented, and it makes a decision, and it recommends action that needs to be taken, which must be endorsed by the regulator.
So the police have, at this point, not responded to your findings. I don't know whether they have, but as of the reporting that we have on our side, they have not yet responded. Is there an opportunity for them to take this on review?
Yeah, definitely. If they feel aggrieved and if they feel that the information, the decision that were arrived at by the regulator, if they were referred to another forum, they could be reviewed and set aside. They are entitled to do so. And unfortunately, in this case, it will be the High Court.
And at this particular point, I suppose, I should also emphasize that it's not just the South African Police Service that should act in this manner. What you've just mentioned is applicable to any business that would have its systems compromised and information leaked in that manner.
Yes, the mandate of the regulator extends, in fact, the Act enjoins us, and it gives us powers to regulate both private and public bodies, or corporates and government institutions. And there has been instances where, for an example, there are some investigations that were undertaken. They are still being conducted at this stage. We're talking here WhatsApp. There has been investigation which are almost complete against the TransUnion ITC. If you remember, there was a leak, there was a data breach or security compromise at the TransUnion, and there's quite a few of other companies that are being investigated. So what we are trying to say now, the advent of POPIA has given at least the data subject certain remedies that they could exercise when their information has been unlawfully processed. And in this case, the regulator is the place where the first port of call, where you come to us when there's been a violation, but also the regulator on its own initiative. When there has been unlawful processing of information, then it conducts that investigation. And this is what we did with the South African Police Service case. We took an initiative after the information came to our attention, and then we started the investigation, and we summoned the South African police to come and explain themselves.
Now, finally, the data subjects, do they now take this information, the findings of the regulator? Can they go with this information maybe for further legal processes if they so desire, if they want any kind of reparation for this misconduct?
Indeed. It actually empowers those victims, to exercise their options, and that could mean, taking legal action against the police, claiming for compensation or damages. There's quite a few other options that they can exercise in this respect.
Appreciate your time. Thank you very much for coming on tonight. That was the Information Regulator Board member, Mfana Gwala, there on their latest finding to the investigation into that Krugersdorp rape victims matter, where personal information was shared or at least leaked onto public platforms.